we have now a provisional patent application. So you may have heard of a provisional patent application in the US, which is an application that you first file and it's not really examined until you convert it into a regular application. So this is a system that we didn't have before. And also, I think the strongest one that we've been implementing is the examination of the inventive step. So believe it or not, French patents until 2 years ago were examined on novelty purposes only. So we had a high rate of grant of patents because only novelty was examined. But of course, at the European level, which remember, we have these two systems with the European level and the French level, the European patents were examined on novelty and inventive step. And so we had this dichotomy between the French patent examined only on novelty and the European patent validated in France on novelty and inventive step. So France now requires all its patents to be also examined for obviousness inventive step purposes. So that means a stronger patent to litigate. Another thing that we've implemented in France is an opposition procedure. So opposition procedure is now similar to what is being done in Europe, which is a procedure that once the patent is granted, you have 9 months to contest the validity of that patent. So it's a bit similar to some of the procedure in front of the USPTO that you may have heard of. So it's a procedure made in front of the French Patent Office, and you can oppose the patent on various grounds such as novelty, inventive step, sufficiency of disclosure. So this means that before this law, you could only litigate the French patent in front of a French court, which is a longer and more costly procedure. But in order to make sure that the economy runs smooth, and you can now get rid of a patent that you consider shouldn't have been issued through an administrative procedure in front of the French Patent Office. So these were the biggest changes in the law that we've been seeing in France for the past 2 years.
Lawrence, if I could just interrupt you here. You mentioned this happened about 2 years ago. Was this always planned? Did it have anything to do with the recent COVID scenario, or was it a political stand that was taken? How did this change come about?
So it's not related to COVID. It wasn't around the same time, but it's just a coincidence. It was introduced by the Macron presidency, and it's called PACT, like making a pact, you know. And it's an acronym for Action Plan for Business Growth and Transformation. So the idea was really to foster the economy, make things simpler for the companies, and part of it was IP. It was a larger global package of new bills for companies, for businesses, and some of it was IP.
Amazing. And how do you see the impact of it right now? I'm sure you see a positive impact, but has it already begun in the last 2 years?
It's a bit complicated because the lifeline of a patent application is longer than 2 years. So it's difficult to see already what are the impacts. But we are certain that this will be a stronger tool for the economy. So we're not worried. I myself already have filed an opposition. You know, we are already argumenting about inventive step. We have numerous conversations with the French Patent Office regarding how they were trained to do this, how this will be implemented. I mean, it's a process being made conjointly with the different actors, and everybody is on board.
Right, amazing. So let me just give our our audience a little background about the general stand. I think Lawrence has beautifully covered Europe, and she's given us an idea of the 2 steps that there are. But in a very basic and a simple way of explaining, I would like to just give a understanding that developed nations are seen to be as pro-IP, right? In the way their intellectual property framework generally is, as compared to developing nations who are seen not so pro-IP, right? So the reason being that the TRIPS required all the signatory countries to comply with every single term that there was in the agreement. However, it allowed certain flexibilities. These flexibilities were allowed to the developing nations. And the developing nations were allowed this flexibility for various reasons, especially economic reasons. For instance, when the time that India signed the TRIPS regulations, India was not was not financially stable and could not really afford to have strong IP laws, especially strong patent laws. And it was seeing a lot of difficulties in the area of affording drugs and medications to its people, right? As long as monopoly existed. And therefore, they didn't allow product patenting at all, which of course changed once they signed the TRIPS agreement. And beyond that, they were required to comply with a lot other regulations. Now, as Lawrence mentioned, there are various flexibilities in the TRIPS agreement, and of course, France is a TRIPS compliant nation, and France probably chose not to have the inventive system up until now, which is quite surprising. I mean, as you mentioned, Lawrence, that I wouldn't have imagined a developed nation not having the threshold of inventiveness. But of course, that shows how pro IP France has been, because it allowed for grants, right? So even with this international compliance that France has come with, and complying with, making it, I would say, standardized with the EU system, it's probably coming even more in a cohesive manner with Europe. So that's amazing. And Lawrence, anything else to add to the European system before I jump into the Indian?
Yes, I don't know if you heard of this, but there are also big changes coming up to the European level. And it's also, I think, a mind frame of strengthening, the patent system, giving more tools to the patent holders and fostering the economy. So at the moment, you have a European patent, but it's a European phase of examination, and then the patent is actually being enforced in what country you select that are part of this European Patent Convention, right? So it's not really like a European patent covering by default, covering like all the countries and being litigated in all the countries at the same time. Because at present, you have to validate the European patent in each country. That means that if you need to litigate it for infringement or validity purposes, you will have to do in every country independently. So this could be costly, take a lot of time, and also the decisions in every country could be different because every country will apply its own set of law. So in view of this, there has been for a long time in preparation a unified court and a unitary patent for Europe. And this is about to come into force in 2022, 2023. So it has been in the pipeline for a long time because we had to get all the signatory country on board. But it's finally coming together. It's very exciting. So this will be an added layer to the European patent, the French patent, and now a unitary patent at the European level. So we will be concerned, yes, it will be all the European countries that have signed also this agreement. So this is getting a little bit complex because at the moment, the European patent cover EU member and some of non-EU members, but the unitary patent will cover only EU members who have signed the agreement. So that means that UK will be still part of the European patent, but cannot be part of the unitary European patent.
Oh, okay. So that's really good. I was going to ask you that. What happens to UK? Because when we file a European patent, we have to still file another UK patent. So,
currently for the European, like what we have currently, there is no change. So UK doesn't have to be a European member to be part of the European Patent Convention. But for the European Patent Court that is coming, then because they're not a European member anymore, they cannot be part of it. And yeah. And so there are some European members who also didn't want to be part of that court, because that court will be in French, English, and German, right? The 3 European languages, official languages.
Right.
So Spain, for example, is not part of that new European patent court because they didn't want to give up on the Spanish language.
I see. Okay, interesting.
Yeah.
That's nice. So I think that's a really good summary on Europe. And just to conclude our subtopic, let me just wrap it up by saying that while TRIPS acknowledges the difficulties and offers flexibility for developing countries, it has been a long-standing argument of the developed nations that some developing countries may have complied with TRIPS in words, but not in spirit, right? So that's basically the long-standing controversy.
Mm.
Yeah. So, Lawrence, anything to add there from the developed nations' point of view?
Well, I'm not sure. When you say you're not in spirit, are you talking about compulsory licenses, for example?
Right. So yeah, so compulsory licensing for sure, but amongst others as well. We're considering we are discussing compulsory licensing, and since our topic invites COVID-related subjects as well, I would like to highlight here that despite India's infamous stand on compulsory license, through COVID, the government did not invoke CL. And that's a big victory for us in a way, because I think with NATCO being one of the most infamous cases, which really triggered the developed nations against us in a way, we were quite mindful, I would say, through the COVID period, and no compulsory license was invoked. Even for remdesivir, which has been granted since 2015, if I'm not wrong. So it does make it eligible to be, a subject matter of CL, but that didn't happen, which says heaps about how probably India is now also coming in line, I would say, in spirit as well as in word. But there were certain other regulations that India did push in, such as the price control regimes for COVID-related drugs and medical devices. But at last, there wasn't a CL. So that's one victory for the IP framework of India. Yeah. How about France, Lawrence? Did you do you also have CL provisions, and in talks with enforcing? Did you enforce any through COVID?
Yeah, so we do have a compulsory license provision in the French IP code. And so at the moment, there was never granted, like this has never been used.
Okay.
Yeah, the system is a bit complex. It takes, it's a judiciary authority that allows it. It takes a lot of talking. There are some various committees that needs to be formed and take decision and publish and this and that. It's really long, complicated. And I guess for the COVID situation, it was not really appropriate in that sense. It's only available for patents. So that means that patent applications are excluded from these proceedings. And so since we know that patents take a long time to issue, for sure the compulsory license for those that are still under examination will not be happening. And so this has never been done. And for the reason of COVID, if I can just guess why it didn't happen, aside of the complexity of the granting process, the lengths to obtain the license, to have all the parties agree, makes it difficult to adapt to the urgency of the situation. Also, it's a French-only system since it applies only on the French territory, and the vaccine situation is a larger situation than just what's happening in France for a French patent. And also, during the heart of the pandemic, we had a mini lockdowns. And so the judiciary system was tailored to address only those that were like priority, and maybe IP matters were not part of what was considered priority. So we had some discussion in the public debate, really, but it didn't happen in the end.
That's it. So I'm sure you've heard in the news and all, the second wave hit India really badly, and they were considering the numbers that we are, it was a disaster. And I was quite surprised that throughout even such an emergency, there wasn't any invoking of compulsory licensing back then. The courts actually said that we can't assume that the companies, the pharmaceutical companies, cannot provide these licenses. We cannot just dictate that they cannot unless it is proven that they haven't been able to, supply their drugs uh, to the people. So we have a 2 to 3 prong test. So number one, the patent should have been granted for 3 years at least, and also that the drug is not being available or provided to the people in India, number one. Number two, even if it is being manufactured and sold in India, it is sold at an exponentially high price, which makes it essentially unavailable to the public at large. So these are the primary reasons for the government to invoke CL, and of course the emergency of its requirement. It was invoked in 2012 by by NATCO for a cancer drug, and at that point the price difference was 3,600 euros per month to 100 euros. So they said, so it was being sold at 3,600 euros per month, but it was feasibly sold, or it was possible to sell it at 100 euros. So looking at that price difference, the courts granted the CL, but ever since there have been 2 requests for CL, and both have been refused by the courts. And this year, I mean, the last 2 years of COVID again, there haven't been CL invoking. Of course, there have been price controls, but there haven't been CL invoking. So I think we are coming a little closer to you, Laurence, towards the developed nations, and probably coming to meet you halfway there. And hopefully, at one point, we will be considered completely compliant with TRIPS in word and in spirit by the developed nations. So
well,
let's hope for that.
That's really cool. So you have practical experience both in India and in the US. So in that sense, like, how do you compare the two systems?
I think that working in US was such an enriching experience. I hadn't seen such a fast-moving IP system. In India, the I would say the steps involved in acquiring a grant are so many. It takes it, at least at that point, while I was in the States, which is more than 5 years ago. And at that point, India was not, I think we've picked up a lot more in the last 3 years than we did earlier. So back then, the US system felt so much more free, so much more, I would say, that's the reason they call them pro IP, because getting a grant there was so much easier in a sense than getting a grant in India. And when we had so many foreign clients who always asked us why their patent was not granted in India if it was granted in all the other countries that they had filed in. So it used to be a very painful situation for us back then. But in the last 3 years, I've seen the system changing, the system becoming so much more welcoming towards patents and innovations. The threshold for a grant is so much, I would say, warmer now than it used to be back then. So comparing US and India, I think I'm happy to have seen the both extremes, but I'm also happy to see that India is now moving so positively towards a pro-IP nation?
From what I've seen, you know, like from moving from the States to France, I think the difference that I saw, and now is becoming smaller and smaller, is the digitalization, you know, like working paperless. And so this, thanks to COVID, has accelerated the way to handle matters through digital, and so accelerating also all those procedure.
Right. That's true. And what about Canada, Lawrence? I know you've spent some time there.
I feel like Canada is a bit halfway between France and the US. So in some aspects, you know, it's a fast-paced environment like in the US, and in some other aspects, it's a bit traditional. So
I see. I always saw it. I mean, when I studied the regimes, I always thought it was more traditional or closer to India than US in that sense. But yeah, that makes sense of being in the middle of the two. Yeah.
France remains a very administrative country. So, for example, to file any paperwork at the French Patent Office, they require our hand signature, even though it's digital. They're required. And so, you know, like coming from the US, it's like, okay.
Yeah, that is strange.
Yeah, it's kind of the tradition here, you know, a lot of paperwork and signatures and.
Yeah, true. I just saw a question pop up here, and it said that what if the developed nations waived IP laws altogether? So wow, okay. So let me give this one scenario through COVID. Right, through COVID, we had. I'm sorry, I wasn't able to see who posted that question, but I just saw the question flash up. Right, so I'm just going to take that up. Lawrence, I think you and I had discussed this scenario through COVID about how people were talking about patent pools and bringing all the inventions together and talking about coming up with a solution for vaccination, etc. Now, if all the countries, or you say the dominating countries or the developed nations is the correct terminology, if the developed nations were to let go of or waive out IP laws, there wouldn't be patents, there wouldn't be trademarks or designs, there wouldn't be that registered information anywhere to pool or to go back to or to resort to. So it's actually a very positive mechanism of protecting that which is yours and offering that to others as well. It's a structure, it's a kind of a framework which systemizes property and the way the property is to be handled. Now, if you don't have such a framework, then it's really difficult to even distribute that property amongst people in the time of need. So through COVID, if we didn't have patents, for example, remdesivir, we wouldn't really know of it in that sense. People would keep it a trade secret for their benefit, and we wouldn't really see it benefiting the public at large. So while there is a lot of questioning on monopoly, it is also a true fact that without such protection or such structured framework, we will not be able to avail the benefits of these inventions to people when there is a time of need, such as COVID. Yeah. Lawrence, would you be happy to take up questions? I mean, I said that we may not have time, so I wasn't sure if we could take up questions. But
sure,
it seems
I can take one.
Yeah, okay. Let's go to the chat.
Is there one for me?
Countries like China and Sri Lanka is another question, but we are not Chinese or Sri Lankan lawyers. But I can just tell you that China is, Lawrence, would you say closer to US now? It's surpassed, I think, US filings, and Sri Lanka would be closer.
I think they also strengthened their judiciary system for IP and their IP litigation. So, you know, like I don't have necessarily a hands-on experience about Chinese litigation, but from what I understand is that this idea that you don't get a good litigation in China. This is not true anymore. So I would be careful about prosecuting a patent, litigating a patent in China. And regarding prosecution, I have more experience. It's actually difficult to get a patent in China. They're very strict on inventive steps. So it's definitely, they found good prior art, and they challenge us on the obviousness of the invention. So I think they are moving toward a really strong patent system, and not necessarily pro-Chinese applicant. I mean, just a regular good patent system. But that's my personal experience.
That's great. That's a very positive thing to hear about the Chinese patent system. Yeah, I remember clients used to be so apprehensive before filing in China at one point, but now it seems to be a lot more just, right, and unbiased compared to what we thought. Yeah, there's another question. I think it's on Indian system. I'll just take that. What are your views on current international IP laws and the national laws of countries, including India, in relation to access to medicines and access to patented technology? So, so like we discussed about the international laws, I would say that all of us, most of us, not all countries, but most of us are signatories to TRIPS. So the basic framework of our internal, IPR legal system is more or less the same, in the sense the standards for novelty or the standards for inventiveness, those, or the concept of novelty and inventiveness, at least that would match. But of course, every nation has its own, regulations. Say, for example, India has Section 3D, which I'm not so sure any other countries have. Probably Africa, but I don't know of any other countries who would have Section 3D. Now, Section 3D was brought in to ensure that evergreening of patents don't happen. And India was particularly afraid of that, because when we really post-independence, we had a very tough time with MNCs manufacturing in India, but literally exporting all the drugs, which left India without any affordable drugs, at least. So when the government put the system together, they wanted to be sure that the people of the country have access to their medicine, right? So that was the reluctance towards product patents in the first place. But after TRIPS, when we had to include product patenting, which would include drugs as well, and medicines, as you call it, we also had included Section 3D, because our fear was not allowing patents on drugs, but it was about the evergreening of those patents. So Section 3D took care of that. And yeah, so that's the difference, I would say, between India and other international IP regulations. Yeah, I think we've completed the questions. Yeah. Lawrence, anything to add here? I think we've covered everything that we had discussed about this chat.
No, this is really interesting, actually, to confront our two views. And
yeah, I mean, we've been friends for so long, but we hadn't ever spoken about our national IP laws. And so this was great. Yeah. So thank you for this. Sushmita, would you like to step in here?
Thank you so much, ma'am, for taking time from the busy schedules and being present here among us students, for sharing your incredible knowledge and insight on this subject. I'm sure everyone will be taking back some valuable learnings from the session. So with this, Students for the Promotion of International Law Mumbai, in association with our knowledge partners, Loctopus Law School and Walters Kluwer, our media partner Loctopus, and our knowledge facilitator Knowledge First, is pleased to announce the end of the 12th Government Law Summit Fireside Chat. Now I kindly request the participants of the Judgment Deliberation Competition 2022 to stay back, because we'll be moving on to the valedictory ceremony soon. With this, ma'am, thank you so much for being here, and we look forward to all future collaborations with you as well, both of you. Thank you so much.
Thank you so much for having me. I'm very, very happy. Thank you.
Thank you.